council designations. We've this morning designations from some of the councils, and now hearing from those that relate to the South Wairarapa District Council. And in particular, I should say the Masterton District Council. Is it?
Yes.
Masterton. In particular, excuse me, we're going to follow the same procedure that we applied for the preceding hearing. We will hear from the requiring authority first. We'll hear from from the reporting officer first at a general level. Then we'll hear from the requiring officer. Then we'll hear from the submitters, and then the requiring officer can, the requiring authority can have the right of reply. So, can I just go to you, Morgan, firstly? Do you want to just take us to your high-level summary and anything you want to draw our attention to in relation to the 42A report, which is dealt with at paragraphs 193 to 204?
Thank you. I'll just refresh your memory. So in section 4 of the summary statement this morning, I read the responses to the pre-circulated expert evidence, and that's where I mentioned Ms. Foster's evidence and acknowledged that.
Acknowledged.
Yes, I acknowledge Ms. Foster's evidence.
Okay.
At the date when she was preparing her evidence, no evidence had been supplied by Masterton District Council as the requiring authority in regard to the Riversdale wastewater treatment and disposal designation. And therefore she was in the same position as me in not being able to conclude whether the requirements under section 171 of the RMA had been met.
Yes, and that was your 42A report was dated the 4th of April.
Yes.
Summary statement was dated the 16th of May, and we had some further information provided by Mr. Evans on the 2nd of May.
Dated the 2nd of May, but it was provided, I think, on the 14th.
It was provided on Friday.
Yes, it is. Yes, it is dated the 2nd of May. I see that. Yes. Okay. Thank you for that. Mr. Evans, are you online?
Yes, sir.
Good morning, Mr. Evans. Thank you for your patience. Morning.
It's okay. I've had to change rooms, sir, so hopefully this works okay.
That's fine. You would have got a feel for the proceedings based on how we ran the preceding hearing. So this is an opportunity for you to talk in support of the notice of requirement for the Riversdale designation. And we have a copy of your memorandum dated the 2nd of May, but only received late last week, being the 14th of May.
Okay. Well, thank you, sir. So just by way of introduction, my name's Phil Evans. I'm the Compliance, Assets and Projects Manager with the Masterton District Council. I've been with the council since 2015 and held a variety of roles in that time, mostly in the environmental monitoring and compliance reporting type of area. And I'm familiar with the Riversdale wastewater treatment plant in terms of its resource consent and the reporting around that. I'm not so familiar with the Eastleigh site per se, but I have had some involvements with it a number of years ago. We've had quite a few staff changes here in the last couple of years, sir, so that's the reason, I guess, why I'm the one doing this and not someone who's a bit further up the food chain, but that's hopefully I can assist the deliberations. I just wanted to maybe just highlight one point in that memo that I sent through, so on page 2, under the response portion, at the end of the second paragraph there's a comment: MDC has allowed this consent to lapse as there were no immediate plans to expand onto this area and there were holding costs. We actually surrendered the consent at the end of 2015. So we went through a process and formally surrendered the consent to GWRC at that time. as there were no immediate plans, and there were some holding cost fees we were paying to GW, which were adding up. So we had a bit of a tidy up and got rid of it then.
Okay.
Other than that, so those are probably the key aspects of it. So the Riversdale plant operates on the balance of that site, on the balance of the designation. It consists of 2 oxidation storage ponds and 1 maturation pond. All the effluent coming in is discharged to land through a series of irrigators, and that crop is then harvested by the farmer who owns the property around the site and used for himself, the livestock, winter feed. And I'm happy to take any questions. So I'm not sure what else I can say at this point. The land was originally, just to clarify, the land that we are talking about here was originally owned by Eastleigh, and that Eastleigh did get the resource consent to discharge and treat wastewater on that site. When Eastleigh joined and tapped into the Marsden District Council reticulator network that was constructed 2009, 2010, there was a formal agreement, an infrastructure agreement, and Eastleigh passed land and consents, some easements, and I believe some financial contribution to hook into that network for the new subdivision up on the hills there. So that's the context by which it came to us. It is a piece of land that we would like to keep designated for future use. It is an area that we can expand onto, and we would like to expand onto if we need to. I was listening to your comments, sir. I'm not a planner. I don't have that background, but I was listening to your comments earlier around the purpose of the designations, and I don't pretend to be knowledgeable in that space. Other people will be more knowledgeable than me. But I do think it's important that we retain that designation so we've got the visibility over what the intended future use of that land is. I think it sort of fairly informs the neighbourhood. It also informs our other documents, such as our asset management plan, their long-term and annual plans, and any other council processes that we have in play. We're also going through at the moment, as you're probably aware, sir, some fairly complex negotiations through the local water done well. And this land's been identified as land that would transfer to a future entity. So it's sort of rolled up in that as well. I hope that's of some assistance to you, sir, and I'm happy to answer any questions that you might have.
Yes. Thank you, Mr. Evans. There's 2 issues that I will need to consider on this matter. The first is the need for the designation or the necessity for the works, and the second is the effects of the works. Those first 2 issues were raised by the Eastleigh submitter, and one of those issues, the necessity of the work, was also raised by Ms. Fallowfield, the reporting officer. And they're fundamental questions that I will need to answer with some confidence in terms of my deliberations and final recommendation and decision. Dealing with, and there is a sort of a nexus between the 2, as Ms. Foster in her evidence has indicated that it's necessary to understand the necessity of the works to also understand what the effects of the works might be. So there's a relationship between the 2 issues. But just on the first issue, I guess the test is whether the designation is necessary and whether the works are necessary. And you've talked about using the land for a future use, and certainly there are 2 purposes of designations. One is to protect land for a future use and make sure that the land is available and safeguarded and not eroded for that future use. And the second function of a designation is to provide enduring authorisation for that use once it's established for the life of the district plan or for the life of the designation. So it's the first aspect that I need to focus on, and that's designating land for some future use. And so and then we're talking about the single lot in this case. I don't think Eastleigh are challenging the designation over the remaining allotments, and I've just indicated that is correct. I guess, and I don't know if you've had an opportunity to read Ms. Foster's evidence,
I haven't seen, no.
No, I'll at paragraph 4.4 on page 5, and I'll just read it to you. She says, the notice of requirement for this designation states that the existing Riversdale wastewater treatment and disposal system has capacity for 407 households, with another 63 able to be serviced. That gives a total of 470 households. The numbers in the NLR, that's notice of requirement, and in the asset management plan align. The approximately 470 households are serviced by the current capacity of the wastewater treatment plant and the disposal fields. There's no indication within the notice of requirement of why Lot 1 DP 451871 is required for expansion beyond the existing capacity provided. And that's it in a nutshell. She's raised a question that really summarises the issue that I need to deal with. And I really want to invite you to respond to that as to why, beyond the current capacity being adequately dealt with, is there a need for additional land to provide some future capacity? Is there something about the zoning framework, or is there something about the long-term plan that would suggest that this additional Lot 1 is required to be designated to provide for that future capacity?
Thank you, sir. I'm probably not the right person to talk about the zonings and the other planning instruments. I mean, this, from an operational point of view, this would allow us to expand, and as if you've rightly noted there is capacity for the existing provision and some growth within that area, within the existing irrigations field. It's a tricky one. I mean, this is land that we would need to use in the future if there's a future demand, if the volumes increased in any meaningful way or any difficult way that we couldn't manage on the current site. The methodology of disposing or treating the water on the site is that it's entirely irrigated to land, so there's no discharge to water, which makes it quite different from the other designation which you heard earlier today. So all of this is discharged to land, and the reason for that is it's on quite hilly, steep country. So we have to hold the water during the winter and the shoulder months, as it were, and then discharge during the summer. This is fine because the peaks come through. The peak for the site is really just over the summer when the population's in Riversdale. But if that was to change in some way, we would need the additional land to irrigate onto. The exact details of when that would happen, I don't know. I don't know if it would happen within the lifetime of this district plan. It would depend entirely upon how rapidly the new subdivisions are taken up. And it might depend upon people changing their lifestyle patterns. So if they were to start spending more time out there and not just the summer months, then that would definitely increase the amount of land we would need to operate out there. There's also, I guess, an element here that this land came to us from Eastleigh as part of the package for the express purpose of future development and future growth. That was the value to us. But without that in there, that would reduce the value of the land to us. If we had to go and acquire some different land or whatever, then that would not be as much use to us for that role. Yes. I'm not sure what else I can really add to that, sir. The projections obviously are that there is sufficient capacity within the existing treatment plants and the existing irrigation for now, up to 470 households. That sounds correct. But as I say, if there were to be more than that, or if there was to be a change in use out there, if people were to say become residents more permanently and not just over the summer months, then that would change the impact upon the treatment plant and the volumes that we would need to discharge, and that would absolutely necessitate further land for that.
Yes.
Not sure what I can add to that, sir.
Right, that's useful. Can I ask, how many ponds are there currently on the at the site?
How many ponds? So there's 3 ponds. So 2 sort of oxidation storage ponds and 1 larger, we call it the maturation pond, things to basically stay in there longer. And
yes.
And then there's a small pump shed with some telemetry equipment in that, and then it's reticulated through those areas you can see on the memo, through some standing sprinklers. Yes.
Okay. And the additional land, let's call it Lot 1, that would be, if it was to be used, would be solely for disposal as opposed to storage.
Well, we haven't any concrete plans here, but that would be my understanding. There are some ponds actually on there, which you probably can't quite see in that aerial photograph, but they are quite clear in other aerial photographs. Those were constructed by Eastleigh for their own wastewater treatment plant.
Yes.
Back in the early 2000s. So whether or not those would be repurposed, I don't know. we had to work out what the best options were for that. It's quite small, so.
Yes. But the intention in the first instance is really to use the land if necessary for irrigation disposal.
Yes, sir. And we do have easements that run across Eastleigh's property from Riversdale Township up to the existing wastewater treatment plant, which cut through, I guess, the northern belt. Well, the pipeline at least cut through the northern part of Lot 1, so it's sort of on those easements and on that pipeline.
Yes.
Which will obviously facilitate any future infrastructure development that we had to do through there.
Yes. Okay. Are there any provisions in the council's long-term plans or annual plans for development of the site? Any line items?
No, sir.
I appreciate your frankness about not being a planner. That's probably a good thing, Mr. Evans. If it transpires that through decisions that the panel, my colleagues make on the zoning of land, particularly the extent of the settlement zone at Riversdale, means that the number of residential properties might exceed 470, then your case might be made. But conversely, if the zoning structure means that that's a cap that can't be readily increased, what's the case then for the future use? Is it solely in terms of change of residential duration from a sort of summer to a 12-month or round year operation? Is that the basis of the case for the use of the land?
I guess something that's certainly valid, I think, sir. But one thing I also didn't touch on really was changing environmental provisions from our friends at Greater Wellington. We are seeing as we go through new iterations of discharge consents that the standards do get higher and higher. At the moment, we comply with those standards. The treatment plants work very well, and we demonstrate that we staying within those standards. If, however, we had to, say, reduce the amount of nitrogen loading on the soil, we would need to expand that. We would need to expand onto a new area, so the same volume might have to be spread across a larger area. That's a little bit of crystal ball gazing, sir. I know that the regional council is concerned about nitrogen levels. We have got some quite stringent provisions on our existing resource consent of how much nitrogen we can put on and take off, and how much fertilizer we can use for that, as you'd imagine. So if those were to become more stringent, then that would require us to expand onto that area then. And I would note, sir, as you say, we actually, I guess a point of difference here is that the MDC does own that land outright. There's no question of being held by a third party or something. So we will still have that option, I guess. Even if the designation wasn't there, we would have to go through and redesignate or do whatever we needed to do if that was the case. But that to me really is the only really likely scenarios having to expand onto that are either increased flows coming in from increased occupancy or more stringent environmental performance standards being put out by, I guess, central government or Greater Wellington Regional Council. But I'll be crystal ball gazing there, sir.
That's very useful. Making notes for that. And will you be able to provide a copy of the current regional consent?
Absolutely, sir. Yeah, 100%.
Yes. And can you recall when that was granted and what duration it has?
2009, and the duration runs through. It's a bit of an odd one, so it's 3 or 4 consents stacked together, but I think it runs through to 2044. But there's some provisions which expire in 2034. I'd have to look at that again, but I can certainly provide you with a copy of that one, sir.
Yes. And just in terms of lot 1, you're saying that consent wasn't lapsed, it was officially surrendered.
Yes, I started work here in late 2015, and there's a number of resource consents which I was asked to tidy up. This was one of them. It was when the regional council was looking at changing their state of the environment fees, and they went up quite steeply, and so the holding costs were looking quite high, and so I was asked to surrender that license, that consent.
In 2015 or 2016, was it?
In the 2015, it would have been, sir, late 2015.
Thank you.
Would you like a copy of that consent too, sir?
Yes, I would, for the record.
Yeah.
Stephen, this would be a new designation over the entirety of the treatment plant and disposal areas. It's just just lot one that's in contention. Have you given any consideration to whether you might wish to volunteer any conditions of consent on the designation?
Well, you're knocking on the door of the planning realm now, sir. So from an operational point of view, we would like to be able to make sure we can operate from the site. So when I guess I'm concerned about things like traffic movement and noise, potentially dust and odour, which I know those are the realm of the regional council, but there's also obviously some district plan rules around noise and traffic movements. Those are the sort of things we would need to just be cognizant of. If there's a failure in the pump system, for example, we would need to attend and remedy that when it happens, and that could be 2 o'clock in the morning. So we need to access the site with that. There is not many buildings on the site, but we'd certainly like to have the ability to put a building close to the boundary, which may, I guess, breach some of the boundary rules. I'm not overly au fait with those, but we do need pumping sheds, earthworks, and those sort of attendant matters.
Okay, thank you for that. That's all from me. Just see if there's any clarification sought from Ms. Fellowfield at this point. Nothing. Okay. Could you stay online, Ms. Stevens? We're just going to hear from the submitter now, and you'll have an opportunity to respond to any matters that they raise before we adjourn the hearing. And then I'll also mention whether there are any directions following that might be similar to the directions I gave earlier, the preceding designation. Okay, Mr. Davies.
Thank you, sir. I would just like to start by sort of acknowledging that we had some reasonably frank evidence today, and essentially the council does appear as acquiring authority, does indicate that this is something of a crystal ball exercise that it's in trying to engage in, and I'm I guess left with the submission that I wonder whether or not designation is the right approach to take. There's no suggestion here that the underlying land tenure is going to change. That doesn't change in terms of designation. And I also observe that the majority of the infrastructure is going to be located on the lots for which the designation isn't challenged. Not entirely clear what precise infrastructure is required, or whether indeed they require district consents at all. Certainly regional consents will be required, but that's not a matter that the designation would provide. In terms of my written submissions, I'll just skip very briefly through those. The first point is I've referred to section 171(1) at paragraph 4. That should be a reference to section 168 capital
Yes.
A3C.
Yes, I made the same mistake.
The words are identical,
Yes.
and the case law to which I refer is the majority is 171, but I suspect one or two of those might be
Do you have a spare copy of your legal submissions too?
I do, yes.
Just save me money. Notes. And when were they filed?
On Friday.
Okay.
So I've got a spare copy to want them.
Thank you.
If you haven't, they don't say anything which.
I haven't read them up.
That's right. I'll take through them in slightly more detail then. I guess paragraph 1 clarifies that it's simply the isolated satellite lot that we are challenging designation over,
Yes.
not the lots on
The remainder of the designation.
the remainder of the designation, the one where the oxidation ponds I call the boot because it's shaped something like a boot, and then there's 2 other pockets of land closely associated with that. What we're dealing with is, in terms of notice requirement, which was attached to this Foster's evidence.
Yes.
It's the piece of land that we're talking about is this piece of land here.
Yes, that's
As opposed to
Sicily.
as opposed to Sicily. Yes, that's correct. Something vaguely like looks like some state of America, but I can't quite pick which. That land that we're talking about is entirely surrounded by land that Eastleigh owns, hence the interest in this issue. And I certainly make the point, paragraph 3, we have been provided with the memorandum dated 2 May. It was provided on the 14th of May. And we've obviously heard additional information today, none of which is of a particularly technical nature. And on that basis, we're probably not prejudiced. Having said that, if further information did come in, which was of a technical nature, we would appreciate, well, I guess my first position was I'd oppose its introduction, but if it was introduced, like the ability to respond to it.
Yes, I mean, I've acknowledged, Mr. Davies, that this is not the normal sequence of events. But I guess I've allowed a little bit of sort of leeway in the sense to try and encourage the information to come in.
Let's focus on the issues, because I think in focusing on the issues, I think we've rather hit the nail on the head, which is paragraph 4, with the exception of the reference there to section 168A 3C, and then the question then becomes, well, what is reasonably necessary for achieving the objectives of the requiring authority, which designation is sought? You've got in the following paragraphs something of a summary of the case law in this area. I'm happy to provide the cases if you wish, but I don't understand there's any disagreement between myself and Ms. Fellowfield in terms of the
yes.
In terms of all of this.
I won't trouble you for the cases.
The test of reasonable necessity is objective, and the objective tests lie somewhere between a subjective test of expediency and an objective assessment of absolutely necessary. Although there's cases which say sort of adding something to reasonably necessary, everybody knows what reasonably necessary means, and adding something to it actually doesn't really help. It's in paragraph 8. Couple of recent High Court decision referring to another decision in the last 10 years. Paragraph 9, I might highlight, the tribunal also implied that if a proposal is unlikely to eventuate, it is not reasonably necessary. We're perhaps not quite in that territory. We're in the, this might be useful depending on future changes, which we don't know when they're going to occur. So unlikely to eventuate is clearly out. But I also note that designations lapse after 5 years unless substantial progress or effort has been made towards giving effect to the designation. So that's a sort of a planning horizon, which is a default provision. And in the notice of requirement, there's no suggestion that any other provision other than the 5 years be provided. Of course, here part of the designation is already being given effect to, and then part of it's being held in reserve. But this is a new designation.
It's a brand new designation over the entirety.
That's right. So I think you can compartmentalize it in that sense and say, well, on the evidence that we've heard this morning, is this going to in fact lapse after a 5-year period, which might point to the right answer in this case. And then in paragraph 10, if the scope of a designation is more than reasonably necessary, the designation should be reduced to what is reasonably necessary. So effectively shrink wrapping to that test rather than taking asking the question as a whole and saying, well, is any part of this reasonably necessary and therefore the entirety is reasonably necessary? That's not the approach that the Environment Court took in North Eastern Investments. In terms of the notice of requirement, as I've noted, that was attached to Ms. Foster's evidence, its objective isn't stated. I have inferred that obviously the purpose of this is to have a wastewater treatment plant, and that's something of an objective in and of itself. And there's a reference even in that document to flexibility to modify infrastructure at later stages as may be required due to changing requirements or new technology. Certainly the evidence we've heard this morning is consistent with that. Eastleigh's position is, initially asking the question, given the wastewater treatment plant has already been constructed and to our knowledge seems to be operating as intended, the question then becomes why this additional lot has been included in the designation, or whether designation can be limited to Sicily, Corsica, and maybe Crete. That's I guess the question being asked. Paragraph 17, I've gone through the memorandum dates that were provided on the 14th of May, dated 2nd of May. We don't dispute paragraph 18. This is, we don't dispute the land parcels owned by the Marsden District Council. The site was initially developed by EC Limited for the purpose of their standalone wastewater plant, and the wastewater treatment plant is operating on other land, and it can be inferred. We haven't had any evidence to the contrary that the wastewater plant is operating in accordance with what's been intended. And we've heard today that it's got consent through parts of it through to 2034 and parts of it through to 2044. So it holds long-term regional consents necessary to operate on that land. There is a comment that the MDC allowed regional consent for this land to lapse, so that lot 1 to lapse, as there were no immediate plans to expand onto the site, and they were holding costs to maintain that consent. So presumably that was a decision that was made in 2015. There was no immediate plans, and there's still no immediate plans, and indeed no plans, because as Ms Foster's identified, there's nothing in the long-term planning documents to suggest that there's any plans, let alone any immediate plans.
Mr Davies, is there any distinction drawn between letting the consent lapse and surrendering the consent?
No, I had understood it lapsed, but perhaps the surrendered even more definitively says you don't want it, rather than simply an inaction. It's a deliberate action. So perhaps my submissions could be corrected to refer to that. I think that's an indication that the council not only indication that certainly in 2015 they didn't want it, and they didn't see a necessity for that consent in the medium term. If they had required it in the short term or the medium term, they would have maintained that consent, because obviously consenting costs for this sort of activity can be significant. Observer 21, there's no detail given as the current capacity of the plant. That's obviously stated in the notice of requirement, and at what point future growth or increased future demand would require the utilisation of this parcel. Similarly, there's no analysis of how the future demand might arise, although we've heard something of that this morning, change in the nature of residential occupancy in Riversdale, and possibly further lots. The question the council does not answer is why it is reasonably necessary in this plan to designate land where, by its own admission, the council has let its regional consents, surrendered its regional consents, doesn't have to be lapsed, change it's surrendered, to avoid ongoing holding costs. If the regional consents were not reasonably necessary, then the designation is also not reasonably necessary. You've heard from Ms Fellowfield, so there's no need to summarise what she says. Simply note by way of conclusion at paragraph 27, we did attempt to resolve this issue long before the hearing. We sought to understand why the designation was imposed. As we understood, it wasn't part of the draft plan as circulated, but I think we now understand why, and perhaps it's a difference of opinion as to what the purpose of a designation is and how that functions. I think that's possibly the difference between us.
Thank you for that. Before I ask Ms Foster to speak to her statement, can I take it that it's I'm going to use the word solely, but is it principally section 1683A that you have a concern with, as opposed to the other sections dealing with effects?
I think it's 3C, sir.
3.
Whether the work or designation are reasonably necessary for achieving the objectives of the requiring authority for which the designation is sought.
3C, okay.
So, I mean, if we don't have enough, well, certainly from my perspective, have much information at all as to what's planned on the site. And while we've heard some of that this morning, and it's not immediately clear to me that actually requires a district consent, but we've better put that to one side. It does seem on the information available that test is not met. And I would submit that despite the fact that you're only required to have particular regard to that, in the context of this case, that is determinative.
What is your client's ultimate concern with the designation?
Just having some understanding. The land's owned by the Marston District. It may be needed in the future for wastewater disposal, but just simply having an understanding of what the time frame for development of that would be helpful. But it's not. Certainly understanding where we are. And so some longer term plans. I mean, this is going to be farmland. It's not an area that is proposed to be developed at this stage. But having some understanding of what is going to occur on land which our client owns, the surrounding land thereof, would be useful.
Is it useful from an effects perspective or useful from some other perspective?
I mean, at the moment, as I understand it, and someone can correct me if I'm wrong, but as I understand, our client's farming it because the grass has to be kept. So I think it's effectively being farmed. But it's simply having an understanding of what the short, medium and long-term intentions of this land is.
No, I understand that, but to what end? So that your client can understand how the operation, if it was authorised, might impact on the land zone settlement?
I don't think there's. I think there's sufficient separation distance that's probably not the issue.
Okay.
Yeah, I mean, it is more sort of having an understanding of what is occurring in the neighbourhood and what the short, medium, and long-term consequences are of development.
Yes, but again, I'm just struggling to understand what those consequences might be if they're not effects-based because of separation distance. What? And I'll be frank here. What business is it of your client? But what's the effect on them as to what might or might not happen with that piece of land? Is there a physical, or is it a structural, or is it strategic?
I guess at some point there needs to be an understanding. I mean, from a farming perspective, of if wastewater is being irrigated, understanding that, and ensuring that there's appropriate fencing if there's any animal or human health concerns or anything else like that. Those steps are taken.
Won't those matters being able to work through in terms of any lease or licensing or to occupy that land? Your client's currently grazing land, you said.
Well, I don't think it's fenced, so I think that happens by default. I don't think there's a specific agreement. I could be wrong, but I just think it's land which is owned by the council, but it's not fenced. I'd have to go and double check my animal law and
Yes.
Marshall's online. He can probably assist, but probably doesn't need to. But I think that it's the landowner's obligation in this context to fence. So the council hasn't fenced it; it's effectively being grazed. But just having an understanding of those normal neighbour issues of just ensuring that the effects of one person's land isn't affecting another's. There's no clear and present concern that there's some problem with wastewater disposal on that side. The clear and present concern is has the statutory test been met? I mean, at some stage, some information about capacities and how close we are to requiring additional works and those sort of things may well be useful, but we haven't found that out. So I'm not necessarily encouraging that information to come out in this process. We can ask the question at some future point in time.
Let me rephrase it then. If the requiring authority was more organised and had demonstrated objectives for the work and necessity for the designation that was clear and compelling, would your client
wouldn't be here. I think if the council had sort of, gone through the statutory test and answered it, we wouldn't be here. I mean, presumably I'm presuming the information is, as you say, clear and compelling. We just simply wanted an understanding of why the designation is necessary, bearing in mind it might impact on, again, got no present plans to have anything other than farmland and the land surrounding, but having a designation there would or could potentially preclude any plans.
Yes.
I'm not sure. I mean,
yes. And so having that certainty would reiterate what you said earlier, that there would be comfort that there was no physical effects because of separation distance.
yes.
And it would give a timeline for the current farming operation.
Yes. I mean,
Anything else?
no. Look, there's the issue is, has the statutory test been met? The issue is not an argument around effects.
Yes.
At least insofar as we understand what the proposal is, which is a fairly limited understanding, to be frank.
So some people might describe that as a principled submission. How would you respond to that?
Yeah, some people might. It's a bearing in mind. Well, I can leave it there, can I? Some people might think it's principled. Some people, but certainly there is no present intention to create something which is adverse to that. It's simply knowing where one stands.
Well, I'm happy to leave it there. I think I've given you sufficient opportunity to explain the reason for the submission and going around in circles a little bit. But this might be a good chance for Ms. Foster to speak to her evidence.
Thank you. Could I first take the opportunity to correct my rookie mistake between the 171 and 168A?
A mistake, yes.
Right, so the provisions in
Roads lead to the Rome.
yes, in each are identical. So there's no change to the task before you. I don't have anything by way of a summary because I had nothing to respond to. So I think just picking up the discussion, why, so what, I guess, at the bottom of this. This is a new designation promulgated more than 10 years after the land was made available for a purpose. And the lapsed or relinquished consent was one that Eastleigh got for disposal of wastewater from its 140 lot subdivision. So there was an expectation that something might happen all that time ago. Nothing has happened, but this is now a new designation. And what we have is considerable uncertainty, actually, with regard to the specifics of what is proposed here. When, why, what circumstances. There was also, at the time, I know Eastleigh was concerned about standards of treatment prior to disposal. So there's genuine interest in whether it fits with the ethos, if you like, of the farm as much as anything. And Eastleigh didn't want to be here at this hearing, so took the initiative to try and find out, to fill the gaps, understand the certainty that might be hiding behind the uncertainty. But, and so there's been a lot of opportunity to make that case. But what I heard today was that this might not happen in the life of this district plan. We don't know what precisely is. There's no long-term plan or annual plan commitments. And we don't know what the thresholds might be for the other changes, population, occupancy being more permanent. And we don't know what changes there might be in discharge standards. So a new discharge would be required, so that depends how taumata otherwise responsibilities play out, but most places around the country are finding that those standards are potentially going to be less stringent than current regional council ones. So that's just more uncertainty. So I think that lies at the crux of it, and whether that is sufficient to enable the power of designation when there are other mechanisms at play. This is a rural zoning, so there was no designation at the time that the constructed wetlands were installed. That are still there. There was a small building, I think pumping. It's a package plant at the time to cope with the first stage of 140. So I think it was for something like 40 lots. So some buildings, subsurface pipe work, there's easements taking the bulk stuff up, but there was some connections from a pumping booth, if you like, through to constructed wetlands and a disposal field. So many of those activities you might find don't offend anything in a general rural zone.
Yes.
Anyway, so it's really a bubble with a designation with a very broad statement or no indication specifically of what is to occur on this bubble as opposed to the rest of Sicily, Crete and Servius, Corsica. It creates uncertainty on a title, makes it unattractive. So
I've only got one question for you, and that's the test of necessity. It's whether the work and the designation are reasonably necessary for achieving the objectives of the requiring authority, putting aside that there's no clear statement of in the documentation as to what the objectives are. Does the test require my separate consideration of the work and the designation, the works and the technique, or are they something I need to consider together?
the tool that you're being asked to consider is the designation.
Yes. Yes.
So in my mind, you have to consider the works and the designation, the intention behind the power of designation, unless Mr. Davies is going to contradict me on that. But that's the way I have always read it, which is what, and it goes to the power that designation has.
Yes.
Which is an overriding power.
You touched on other mechanisms and you touched on the rural zoning as a site for the disposal of treated effluent to be irrigated. Have you addressed whether that might offend any rural rules that need a rural consent under the PDP?
I haven't. There were, under the operative plan, setback requirements for irrigation of treated wastewater. I do not know what they are currently under the proposed. I haven't looked at it.
I think that's good to know.
And whether it was in relation to rural boundaries or just residential ones. So
Yes.
that's a.
So there would need to be the equivalent provisions or similar provisions in the PDP.
Yes, if it's to trip, yeah, yes, absolutely. But that was for, but there were different standards for drip coming from above as opposed to subsurface. Yeah.
Yes. Any other rules that you might point me to?
Think of any up to my head, no.
Okay, that's all from me. Ms. Fallowfield, are there any matters that you want to respond to before I ask Mr. Evans to give the final response?
No, thank you.
Mr. Evans, the floor is yours now. This is an opportunity for you to respond to anything that you've heard from the submitter. Not a chance to summarise your case again, but is there anything arising, bearing in mind that it's largely planning and legal matters that we've heard?
Thank you, sir. I think maybe just a comment that the land is actually leased back to Eastleigh, so that parcel of land is leased back to them. I just hopped into our DMS while you were talking, sir, and it was re-signed in December last year. So for 5 years plus 5 years right of renewal, so for another potentially 10 years, it's been leased back to them for grazing as was noted by council. This is just to keep the grass down, keep it tidy. So other than that, so no, I think I do believe there's value in having that designation for us. Leaving aside the legal side of things and the discussions at that level, I believe it's important as it helps to inform the community about what's going on. If anyone applies for a LIM, the land information memorandum in that area, designations show up and it'll be identified on those LIMs that this is a parcel of land owned by council with a potential future use. And that to me is quite valuable. But apart from that, I don't think I can add anything else, sir. But thank you for the opportunity.
Yes. Thank you, Mr. Evans. I don't have any further questions. I do need to reflect on whether I'm going to direct any further action or not in this case. There are some differences between this and the Payne Farm situation that in the Payne Farm instance does require me to issue some directions that I've already given verbally, but I'm going to reflect on this instance, and I will make I'll issue a minute towards the end of this week along those lines. But in the meantime, I declare the hearing adjourned. Thank you all for your participation and the spirit in which you've entered into it. Hearing's adjourned.
Thank you.